been inseparable. It's a general notion that anyone who does anything wrong should suffer. Based on this perception only, every wrongdoer or person who commits a crime should face the similar consequences. Thus, retribution was the core idea behind inflicting punishment on a person who committed a crime. Therefore, punishment has always been evil or harsher in nature, so as to make the person realize that he is made to suffer because of the wrongful act committed by him. In order to understand the concept of punishment, it is quintessential to understand the concept of crime. Essentially, every society is regulated by a certain set of rules, ideologies, and customary practices, which are followed by all with the belief that they are beneficial and favorable for overall development of all. Anyone who tries to violate these practices are classified as antisocial. Thus, crime has been defined as antisocial, dissolute, or aberrant behavior. As Roscoe Pound has very rightly said, and he has commented, that a final definition of crime is impossible because law is a living and changing thing which may at one time be based on sovereign will and at another on juristic science, which may at one time be based on sovereign will and another time may give much room for judicial discretion, which may at one time be more specific in its perception and at another time much more general. Halsbury defines crime as an unlawful act which is an offence against the public, and the perpetrator of that act is liable to legal punishment. Thus, unsuccessful attempts have been made to define crime precisely from time to time. However, it is a Herculean task, reason being the nature of crime varies with change in time and place. Variation in the concept of crime is not only based on the value system of any society, but is also dependent on the political and economic structure of a society, form of ruling government in a jurisdiction, and on number of other factors. Punishment has always been used as a mean to control crime in society. It normally involves deprivation of freedom, infliction of pain on the human body, imposition of monetary restraints. It involves imposition of some burden on the aggressor or withholding some kind of right. The Black's Law Dictionary defines punishment as any pain, penalty, suffering or confinement inflicted upon a person by the authority of the law and the judgment and the sentence of a court for some crime or offence committed by him or for his omission of a duty enjoined by law. This lecture will mainly focus on the traditional forms of punishment which were prevalent in the olden times. So, before I go with that, I would like to discuss with the purpose of punishment. So, prevention of crime is one of the biggest objectives behind imposition of punishment for the offender or the wrongdoer. Punishment for the wrongful act or omission sends a strong message for the masses as well as the individual who has committed the crime. It causes deterrence in their mind, which in turn deflects them from commission of crime in the future. Thus, it helps in making the society a safe place to live. It actually demoralizes the offender from the commission of crime again. Harsher punishments were considered as to have a direct relation in the prevention or recurrence of crime. Punishing the wrongdoers is the primary duty of all civilized states. Though retribution has always been the primary objective behind imposing punishment, however, in the recent past, the perception towards punishment has changed due to transformation in the value system and public opinion. Problem in the modern times is how to treat the offender, whether the criminal should be considered as a nuisance for the society at large and to treat him as an enemy of the state, and or it must be abated or he should be treated as a patient. By and large, the foremost objective of a civil state is to ensure safety of the masses and punish the criminals as per the law. In this way, the incidence of crime can be curbed either by creating deterrence in the minds of prospective criminals or prevent the recurrence of crime by incapacitating them or by using punishment as means of reformation of astray minds. So, now I will discuss the different forms of punishment, and to go by that I will be telling you about the corporal punishments. Punishments are of different types. Traditionally speaking, punishments were of corporal in nature, that is, the ones which caused bodily pain to the person convicted of any offence. Bodily pain or suffering was caused to seek retribution from the wrongdoer, as well as cause deterrence in the mind of the person who is accused, as well as in the minds of the general public. Such punishments were given in open spaces, in the full public view. Moreover, public announcements were made to inform the general public about such punishments. This caused fear and deterrence in the minds of general public, and they in turn refrained from committing such offences as they were fully aware of the consequences that they will have to face in case they get involved in such kind of offences. Different forms of corporal punishment were flogging, whipping, pillory, branding, mutilation, thrashing, etc. Corporal punishments were abolished in India in the year 1955. The only punishment which causes some kind of pain, that is the capital punishment. It is still prevalent in India. Another forms of punishment, they are non-corporal in nature. These are such form of punishments which did not expressly cause physical pain to the body of the criminal. Banishment, solitary confinement, imprisonment, ostracism, etc. are such forms of punishment. Although some sort of suffering and hardships was a characteristic feature of such forms of punishment. Ancient or traditional forms of punishment now I will be talking about, and to start with the first form of punishment, that is flogging or whipping. In the Indian context, this form of punishment was widely used to punish the criminals. The Whipping Act 1864 authorized the imposition of this punishment. This law was replaced in the year 1909 and later abolished in the year 1955, as this form of punishment was construed as barbarous and cruel in nature. This form was abolished from the English penal law even prior to that. However, Middle Eastern countries still follow this form of punishment. As regards the effectiveness of this form of punishment is concerned, researches made by different penologists lead to the conclusion that it was not an effective form of punishment, as majority of the offenders who were subjected to this form of punishment resorted to recurrence of similar type of crimes. This form was effective only for minor offences and proved ineffective for heinous crimes. As regards the concept of flogging is concerned, this is a very old form and rather the most prevalent form of punishment in the olden times. The next form of punishment which I will talk about, that is mutilation or incapacitation. Mutilation was a very common form of punishment. It was corporal in nature and it was prevalent in the ancient times. This mode was of common usage during the Hindu period, in the ancient period. The objective behind this form of punishment was to chop off that part of the body of the offender which was involved in the commission of the crime, so that the person cannot commit the similar crime again. Thus, the objectives of retribution, deterrence as well as prevention were achieved by this punishment. This punishment has been commonly used for persons guilty of theft, sexual offences, etc. This form of punishment enjoyed currency in the United Kingdom and many European countries. However, it has gradually gone out of practice owing to the barbaric nature of the punishment. This form of punishment still has prevalence in certain Arabic countries. The next form of punishment, that is branding. Branding was a mode of punishment which was used to identify the criminals. This was done by forcibly engraving marks or signs, typically reflecting the nature of the crime on the bodies of the criminals. Branding was intended to leave a permanent mark, serving as a reminder to the criminal about the offense and enabling society at large to identify them as a threat. The brand was usually engraved on a part of the body that was visible. This visibility, combined with the permanence of the mark, was intended to generate stigma for the guilty person within the larger community. Additionally, it was meant to serve as a warning to the masses to refrain from committing a similar crime. The Roman Penal Code prescribed branding as a punishment, with officials branding the foreheads of criminals with marks relating to the crime committed. This form of punishment has also become obsolete in conjunction with evolving human rights jurisprudence around humiliating and degrading treatment. This can be seen in the Indian context too, where several police officials who were convicted for tattooing pickpocketer on the foreheads of 4 women. The women had to live with the tattoos for over a year before they were surgically removed. During that period, they faced extreme stigma and alienation from the community. The police officials, they were convicted nearly 23 years after the incident took place. The next form of punishment, that is stoning. Stoning was another form of barbaric punishment which was in common usage in ancient times. Such form of punishment was used in serious offences. The accused was made to stand in a trench dug in the ground, and the general public was asked to pelt stones at him. Pelting of stones used to continue till the person died because of the injuries sustained in the process. As this punishment was given in public view, it had a deterrent effect on the masses. Such form of punishment was commonly used for punishing the offenders of sex crimes. In modern times, civilized states have completely abolished such form of punishment. However, in certain Islamic states, such form of punishment is still in practice. The next form of punishment is pillory. Such form of punishment was again prevalent in ancient times only, and the civilized states have completely done away with this form of punishment. This form of punishment had prevalence only till the end of the 19th century. The characteristic feature of this punishment was that the head and the hands of the offenders were locked in the iron cage, as a result of which he could not move at all. Such form of punishment was also given in public view. Whipping, flogging, or even stoning was also done while in pillory. The next form of punishment is fines. This form of punishment is used mainly for less serious offences. And this particular form of punishment, it is not that ancient, it has developed over a period of time. It is used to penalize offenders of property crimes, embezzlement, fraud, theft, gambling, loitering, etc. This punishment is of common usage across the globe. The punishment burdens the pocket of the offender and in turn deterred him from recurrence of the same. In India, this type of punishment is used as a means of disposition, as an alternative punishment, and as an additional punishment. The courts are given the discretion to impose the amount of fines, although the criminal law provides for the maximum punishment which can be imposed in the different crimes. Section 421 of the Criminal Procedure provides for the recovery of the fines. The code provides that when a court levies fine as a whole or part of the punishment, such an amount may be paid to the victim of the crime as compensation for injury or loss suffered by him. This punishment is basically an advent of the modern times. In olden times, this punishment was not that prevalent. Another form of punishment which I will be discussing, that is imprisonment. In primitive times, there was no concept of prison and the punishments were mainly corporal in nature. The punishments were awarded instantly and were executed in public view. It was gradually that the prison system evolved and the imprisonment as a mode of punishment was recognized. In olden days, prisons were built in dungeons and were dark places with limited ventilation facilities. Depending upon the gravity of the punishment, proportionally the criminals were imprisoned in the jails. In earlier times, the criminals used to rot in jails as they had nothing to do in the jails, as a result of which their physical as well as their mental health deteriorated. It was later in time prison population was utilized by the state for doing some productive work. This change had a very positive impact on the health of prisoners. Reason being, they were busy because of work and the feeling of worthlessness disappeared. Unnecessary negative thoughts by which they were gripped earlier disappeared because of involvement in the work. This form of punishment is most popular form of punishment throughout the world in modern penology. The next form of punishment which I will be talking about is solitary confinement. This mode was used to punish hardcore criminals in medieval times. In this form, the prisoner was kept in isolated cell, devoid of any contact with the outer world. The negative impact of this punishment was so severe that it affected the mental balance of the person and even used to prove fatal for the prisoners in number of cases. The idea behind this sort of punishment was to eradicate the offender from the society, thus preventing the recurrence of crime and in turn protect the society from untoward elements. The isolation cells in which the prisoners were placed were dingy, dark and unhygienic spaces. Peculiar feature of this punishment was the monotony and isolation. Man, being a social animal, when placed in such kind of environment, led to the decaying of mind and body of the criminals. Some of the noted criminologists view this form of punishment as means of putting an end to the criminal without even resorting to any form of bloodshed. This form of punishment, it has developed and has been incorporated by the civilized states in their respective criminal laws. The next form of traditional or ancient form of punishment which I will be discussing, that is ostracism. This is another form of traditional punishment prevalent in the ancient societies. In this punishment, the offender was socially boycotted by the entire community or society. There was complete excommunication with the offender and no one was allowed to talk or interact with the offender. In independent India, ostracism is not a legally recognized sanction. However, such form of punishment does exist in certain rural areas where the offender indulges in any act which is against the customary norms of the society. The next form of punishment which I will be talking about, that is banishment. This was another form of punishment which had prevalence across the globe for centuries. The main objective of this punishment was to take the criminal far away from that place where he has committed the crime. This form of punishment is quite similar to transportation of criminals. In England, this punishment was quite in use in olden days for transportation of war criminals to far off Austro-African colonies. This was also a popular form of punishment in France and Russia. The whole objective of this punishment was to make the society free from the criminals by sending the offenders to far off places. As the access to means of transportation were limited, so it was not possible for the offender to come back. The practice of transportation had prevalence in British India as well. This punishment was popularly known as Kala Pani ki Saza, as the hardcore criminals were transported to Andaman and Nicobar Islands. The idea of being transported beyond seas had a strong deterrent effect on the criminals. This punishment was quite popular till early 40s and came to an end when these islands came under the control of the Japanese. This punishment was finally abolished in the year 1955. The next and the most severe form of punishment which I will be discussing, that is death penalty. This is the most severe punishment which could be given to a human being for the commission of crime. Capital punishment was generally awarded to criminals who have committed very serious or heinous offences. The modes of execution of this punishment have been different in different times. Death penalty was awarded by public hanging, death by stoning, death by pillory, etc. This punishment was considered to have a deterrent effect on the prospective criminals and used to deter them from indulging in any such acts in future. Many countries have abolished capital punishment as they consider this punishment as inhumane and barbaric in nature. India has still retained this form of punishment. However, a lot of debate is going on for its abolishment. These are few instances of different forms of punishment prevalent in ancient times. However, these forms of punishments have undergone a great change in the modern context. Majority of corporal punishments have been totally done away within most of the civilized states. Even the nature of the forms of punishment has changed considerably. With the introduction and acceptance of reformatory approach of punishment, the gravity, nature and modes of punishment has also changed considerably. The basic purpose of punishing an offender under any criminal justice system is to reprimand the offender for violating the laws. Nature of the punishment should be such that it deters the offender as well as the prospective criminals from indulging in similar acts ever again. Prevention of mischief has been regarded as the sole aim of punishment by Bentham. Infliction of punishment on the offender should have retributive, deterrent, restorative and rehabilitative effect on the accused and the potential offender as the main objective of the punishment. Certain attributes of punishment have been universally accepted world over, such as that punishment should be generally harsh, evil and unpleasant in nature. It must be inflicted only upon the violation of the laws or set of rules. No innocent person should ever be punished, that is, only the guilty person should be punished. Punishment should be proportionate to the nature of the offence committed. Moreover, punishment can be granted as well as inflicted only by the appropriate authority. Every criminal justice system works on the objective of punishing the violators of the law, so as to make society a safe place to live. Guilt of the accused should be determined conclusively before any punishment is granted to him. While granting the punishment, the object or motive behind it determines the type of punishment to be prescribed. Whether the motive of punishing the offender is to deter the minds of the people or to prevent crime in society or to make the convict pay for his act, etc., are few determinants upon which the quantum of punishment will depend. With this, we come to an end of this particular episode where we have discussed punishment, its interrelationship with the crime and different forms of punishment which were prevalent in the olden times. Thank you.